There is not sufficient judicial activism in Mauritius. We would wish to see more judicial activism, especially when it comes to fundamental rights. A busy lawyer should do at least 1/3 of his work should be pro bono. The bar has got to be independent from the opposition and the government of the day.
Of course.
You can't just toe the line of the executive because that suits your financial interests.
Hi everyone, I've got a small favour to ask. I know that many of you have been watching these conversations over the past couple of years with people who inspire. It would mean a lot to us and it would help us continue to have these conversations if you would just subscribe to the channel. Thank you. Mr. Domingue, welcome.
Well, thank you for having me.
It's a real pleasure. I've been pestering your junior for a number of months, sitting at the back here today, because you're very highly regarded in the profession. So I'm very grateful that you made time today. I guess the first question I had for you, because I always like, before we talk about the law, to understand a little bit more about the person. Did you choose law or did law choose you?
No, I chose the law because as a young boy I was very attracted to the law because my father was corresponding with the Inns of Court at the time and he had several documents. So I was trying to find out what these documents were all about. And the subjects which I studied at college, Royal College Group at the time, were more geared towards the law. And I had read history, A level, and I had also subsidiary, I had British Constitution, which was a rather novel subject at the time. So there was a lot of law which was involved. So I wanted to make law my career and to go and read law to at the Inns of Court. Well, 3 years at the time, Inns of Court School of Law. There was no LLB. That was before the Ormerod report, which came, I think, in 1976.
Right, so one didn't do a law degree, you went straight to the College of
At the
Law.
time, before 1976, in 1976 came the Ormerod report. You couldn't be a barrister or a solicitor unless you went through the LLB, and you had to score a 2-1 or 2-2 at best. So these were the good old days. But then finally, when I applied for scholarship, French scholarship, those who came after the laureates, they were given the French scholarship, because the French scholarship was well provided for. And in the wake of Colin Davelu, who obtained the first scholarship, the first one, he had to go 2 years in Madagascar, and then 2 years in France, Aix-en-Provence. I was more fortunate than he was.
You didn't have to go to Madagascar.
In 1972, I was selected, so I applied. I was selected, and I went straight to France, and I read law for 4 years in France at Montpellier, University of Montpellier.
So then
And I caught up with Ivan Colin Davelu there. I met him once in, I think it was Aix-en-Provence. Either Aix-en-Provence or else sur la promenade des Anglais à Nice, I think.
Nice.
This is where we met so many years later. He was 2 years before me, together with the former Chief Justice, Kapuldev Mataldin, Manu Mataldin. They were in the same class. I think they were 2 years before me.
Okay.
Well,
Okay.
they were my seniors.
And what was it about law? I mean, you were attracted to it as a little boy, but what is it about the practice of law in itself that attracted you?
I'd like to be of service. I might suffer an injustice for myself. I might take it in my stride. I feel that it is wrong to leave something, you know, someone who doesn't have the means of defending himself, someone who is especially uneducated, deserves to be represented, properly represented, and to have his voice heard, so that his rights may be upheld. This is what has attracted me to the practice of the law as a barrister, more specifically.
So to do litigation?
Yes, I was selected after college because of my results. I was invited by former Chief Justice Maurice what called me, wanted to ask me whether I was agreeable to go and study with a notary and to be qualified as a notary after 4 years or so.
Okay.
Because at the time, you had to go through articleship and then the exams, intermediate and final exams. So I told him, no, I'm not interested. I prefer to be a barrister. I'm not interested to go and work with as a notary's clerk.
Yeah.
Because that was the way it was. You had to be article with a notary for a number of years. Then you had to pass the examinations. So these were the episodes, so to say. So I stuck to my guns, and finally I made it as a barrister.
When you look at the practice of law today as a litigator compared to when you started, what would you say has changed the most?
Many more barristers, many more courts.
Is that a good thing
modernized.
or a bad thing?
Yes, I think it's a good thing. Because you have persons who come from they don't just come from one particular, social, cultural background. People with different skills also. Therefore, I think it's a good thing. People are well represented. But now you have got many more cases than there were at the time. There were few lawyers, but there were very few briefs. Now there are a lot of briefs in all sorts of areas, and the law has developed exponentially. Yes. The statute book is now beyond control. So you need to have specialized lawyers also. And this is why now you no longer require a law degree to be a barrister. This is why this is so. So I think it's a good development in the law. It makes for better justice, more specialized justice also. Because you can't have a command of the whole of the law. You are bound to specialize one way or the other. And over the years, you become known in a specific field. People come to you for a particular area of expertise which you have developed.
And is there a particular area that you prefer out of all? I suppose over the course of your rich career, you've touched a bit of everything. Is there a particular type of law that you personally
I like to do some criminal law occasionally. And I also like to do industrial law cases, because I've done a lot of these over the years. Before the ERT, Employment Relations Tribunal, the Conciliation Service, and so on, with the trade unions. A lot of trade unions have come to me. I've done a lot of industrial court cases, and I have also had cases before the Privy Council. And you will see there is a host of cases which have gone to the Privy Council through the labor law route.
Yes.
Several cases. This has become the bread and butter of the profession over the years. Labor-industrial relations, it's a lot of disciplinary committees and so on and so forth. So labor relations, collective bargaining, that sort of thing.
Is there a particular case that has stayed in your memory as being either a memorable case or a challenging case, but that you somehow it still...
There was a case which took a long time to reach the Privy Council. It reached the Privy Council after 20 years. And that was a case where the teachers, the secondary school teachers, they had been sacked by the employer, Mr. Bakaran Bandu, who was the owner of a college in Katobol. And after they had been dismissed, the case went to the industrial court through the labor office. Finally, it was managed by Counsel, took over. And there were no less than 3 magistrates, different magistrates, presiding magistrates, who had heard the case, one after the other, part of the case.
So it started anew each time.
The third one delivered judgment. That was before Wong. So when the case went on appeal before Chief Justice Glover, he was bound to remit it back. So they appointed a special magistrate to restart the case from scratch. And I stepped in after the demise of Malenga Jador. Malenga Jador took over. The first one there was Colin Davilu, and there were no less than 3 magistrates. So we had to start again with Malenga Jador. Then Malenga Jador passed away. I took over from him. I concluded the case. I was on appeal also. And we won an appeal, and we went to the Privy Council, and we won. 20 years down the line, finally the teachers managed to obtain the
justice.
compensation. Yeah. 20 years.
Were the law lords critical, or did they make any comment on the length of time that it took? Because
No, they didn't, because it was an explainable delay. There was a reason behind it. And then the Chief Justice, once he had remitted the case back, because a case which there were several plaintiffs, so it took some time, when various, at least 3 categories, so it had to take some time, and the Chief Justice was right at the time to appoint someone as a special magistrate to go and, attend to that case at the Industrial Court on a full-time, almost full-time.
Yes.
So we managed to conclude the case fairly,
dispose of the case efficiently.
Fairly quickly.
Yes. After 20 years.
Well, it took
eventually
20 years on
to get
appeal
there.
and so on to get there. But then the first part of the delay, because there were no less than 3 magistrates who had heard part of the case as they went along.
And I think this brings me to my next question, which is very topical at the moment and which is being discussed in all sorts of forums, is the proposals for judicial reform in Mauritius. And in particular, people are talking constantly about the proposed new Court of Appeal. The new Attorney General has made a number of suggestions and comments and has done a number of trips to talk to the guys in Singapore, etc. What are your thoughts on this?
I think he's right. It's overdue. We have been discussing about such reform for a number of years now. One of the difficulties which we have encountered is the fact that the judges, once they are appointed, as you well know, they are appointed in dual capacity. They have got original and appellate jurisdiction as well. So one day you sit and appeal over my judgment, the next day I sit and appeal over your judgment. That is a remnant of the colonial rule, obviously. So we have not managed to sort of get out of this equation. And some of the judges have been very hostile. They said, but we should all then have the choice of going to the appellate court. Because when we were appointed in a dual capacity. So most of them wanted to go and appeal. So this is where there has been some problems which have been encountered. And I hope that now with the 60-0, they will be able to find a way out of it.
Yeah.
And to have a completely independent Court of Appeal, which is in a different building, manned with different staff, different codes lists, and so on and so forth.
Yeah.
That is long overdue. And in the event several times in the Privy Council, this has been observed. But don't you have a Court of Appeal in Mauritius which provides guidelines and so on and so forth? So you can't expect judges who have to do chambers work, who have to deal with trial cases in the courtroom, and who have to deal with a host of various cases, to also sit and appeal, over the judgments of their own colleagues in the same building. And it is virtually the same cause list as for the original cases.
Yeah.
So it is something which has got to be rationalized. And you know also that the decision of the Chief Justice, the composition of the bench, dictates the right of appeal. If you go and apply for judicial review before one judge, then you have the right to appeal to the Court of Civil Appeal.
Yes.
And then you may yet go to the Privy Council, but if there are 2 judges who sit and hear the case when a plaintiff is summoned, the case goes straight to the Privy Council. So that is another anomaly which has got to be addressed. It's either 1 tier, 2 tier, 3 tier. You have to make up your mind in accordance with international best standards. The right of appeal cannot depend on the composition of the bench.
Yes.
Which is the case now, which is something which has been regarded for a long time as being rather anomalous.
And what are your thoughts on there have been some, I wouldn't say resistance, but some comments made about the proposal to have foreign judges sit on the Court of Appeal. Do you think that's a good thing, a bad thing, neutral?
Oh, I think it's a good thing. It depends on the percentage of foreign judges. Because in any event, the final Court of Appeal is in London. But it is the final Court of Appeal of Mauritius. They are not foreign judges. They are Mauritian judges It is in the Constitution. It is the final court of appeal of Mauritius. It happens to be the Privy Council, and the Privy Council, I think, has got a record which speaks for itself. That is not a great difficulty, because the idea was to have some of the former judges from the Privy Council to come and sit on the local court of appeal.
Which I understand is the case in the Singapore International Commercial Court.
Yes.
You have Lord Mance and
Exactly.
And other, yeah.
Exactly. You need to go for the best. And you have to set the standard. And once you have set the ball rolling, then it's a question of attracting the right person to the Court of Appeal.
Yeah.
Because you must think of the foreign investors also. Right? And then the Privy Council would wish the standard of the Court of Appeal to sort of be improved in view of a number of observations which have been made over the years.
Yeah.
I think,
And hopefully that will also reduce, because I was commenting on that last week. I was talking with a colleague on a case that I recently did in February, and I observed that not everyone has the luxury, I call it a luxury, of going to the Privy Council because it's expensive. There's not always the means. So if you result in a court of appeal where the standard is pulled to the top, then it might reduce the number of cases
Yes.
that do go to the Privy Council.
yes, that is
because
the
not
idea.
everyone can afford to.
That is the idea. Because in the Privy Council, it's not so much the cost and expense. The cost and expense is not that high. Because a lot of cases reach the Privy Council pro bono. The difficulty is that when you have to advise a client who doesn't have a lot of means, and you have to tell him that there is a substantial risk that if we lose, costs are going to be awarded against you.
That's what I
And
mean.
if costs
yeah.
are going to be awarded against you, then you are wiped out and you lose your house and you lose whatever you have. So that is a matter which is a deterrent. So this is why it is best to have a very strong court of appeal which is able to deal with these cases so that the number of cases which eventually find their way to the Privy Council will be drastically reduced.
Yes.
This is the way I look at it.
You also mentioned the 60-0, which I think is a golden opportunity to make reforms that perhaps may not be available in other situations, other types of composition of parliament. Are there any constitutional reforms that you think our country would benefit from, that is urgent and required or desirable?
This has been debated on a number of occasions. There are the fundamental rights which are protected in the Chapter 2 for the time being. These are not third-generation fundamental rights. Now you have got what they call third-generation fundamental rights. For example, the right to health, the right to education, the right to wholesome water, the right to breathe clean air, ecological concepts, and so on and so forth. These have not yet found their way into the Chapter 2. They will have to find their way in Chapter 2. There is no doubt about it. One can also think about the new Court of Appeal. So we have to restructure the whole of Chapter 7, the judiciary. And we have to give thought also to public interest litigation.
Which is not available.
Which is not available, which should be available for the same reasons as they are available in India. But that has been fashioned by the Supreme Court of India, by the justices. Our own justices are very reluctant to go down that road. There is not sufficient judicial activism in Mauritius. We would wish to see more judicial activism, especially when it comes to fundamental rights.
Yes, I mean, we've seen that, I wouldn't want to call it judicial activism, but we have seen this sort of, I would say, very generous, purposive approach in the case of EcoSud.
Yes.
If I remember correctly, one of the arguments of the EcoSud was at least founded on that concept of public interest litigation and the principles thereunder.
Yes.
It was the right conclusion, but they had the law.
Yes, because it is a matter of public interest.
Exactly.
It concerns the whole of the community. So you have to fashion new rules. But our court has been rather timorous in that direction.
Why do you think that is? Do you have a...
Probably they are overworked. Probably they don't want to have more cases than they can handle.
Yeah.
because of that. So say you don't have a substantial interest. You're an interloper, you're a busybody, you're a crank, you don't have a direct interest. And you will have seen in the Constitution itself, it says that it has been breached in relation to him.
Yes.
If you look at Section 16,
Yes. It's very
the
specific.
fundamental right has been breached in relation to him. And this has been in a tax case, that has been explained, that has been rationalized. So you have to go beyond that. So you have to introduce in the Constitution the concept of public interest litigation as it obtains in India, but with the necessary safeguards, I hasten to say. Because
Yes.
otherwise,
Open the floodgates.
you open the floodgate and anyone can come and say whatever he wants and waste the time of the court. I think in India, you have to persuade the judges that this is in fact a public interest matter. So they won't look at all the cases. Maybe 20% of the cases get looked into at the end of the day. So you need the safeguards. I had addressed that issue in the course of a legal conference which we had in Gambia. And I told them, well, it's a good thing, but then you need safeguards. Yeah. But in a country such as Mauritius, I think it's worth having public interest litigation.
Yes.
Because a lot of people cannot look after their own interests, cannot defend themselves because they are illiterate, they don't know, they don't have the means. So it's a good thing that someone can write to the court and say, this is a public interest litigation matter. My rights are not involved, but I'm aware of what is going on. I write a letter and the court immediately sits and hears the case.
Yes. Yeah.
As a PIL case. Yeah. Nothing wrong with it.
I don't know whether that would be suitable, but we had someone last year from the DPP's office talk to us about many rumors or cases of forced labor in Mauritius.
Right.
And these people are defenseless.
Exactly,
Most of the
they are
time they don't understand
defenseless.
the language, they don't have the means, they are afraid for their own lives, for their own safety.
Just like the writ of habeas corpus. What is a writ of habeas corpus except a public interest litigation, if you come to think about it? Habeas corpus is public interest litigation. You are aware of certain facts. You go to a judge and tell him, this man is being detained against his will. Please act. And the judge acts upon it and looks into it. This is also public interest litigation. It's already there. So it's how you read the Constitution. It seems that our judges have got a rather restrictive reading of the Constitution. Although they have been told time and again that they need to read the Constitution in a purposive manner, and this is the approach in India, this is the approach in the United States. Here it's a rather timorous approach.
And also to consider it as a living, breathing document that lives throughout time. So the way one interprets the Constitution 50 years ago might not be the way we interpret it now because things have
because
changed.
society has moved on. Society has moved on, and you must look at the context also, and you have to give meaning to the words. And you need to know how to apply it also. If you apply a rather restrictive interpretation and you look only at the words, then you're not going very far. Because one could not in 1968 predict, all the developments which have happened subsequently. Yeah. And it is fortunate also that in 1982, 1983, we had these amendments following the 60-0, which prohibits Parliament from extending its lifetime.
Yes.
As they have done for the municipal councils, you see?
Yes.
And the court went along with it.
Yes.
So we have had two judgments saying that Parliament can extend the lifetime of municipal council, which I find it very difficult to accept such a proposition.
Well, I'm hopeful. We are all hopeful that some of these reforms, now that there is the opportunity to have them, that they will be made. The other aspect I'd like to explore with you is the ethics of barristers. We've heard a lot about it in recent times. I guess my question was going to be quite broad, actually. I don't want to pinpoint on a specific issue, but I wanted to ask you whether, do you see any particular concerns based on the way the profession is being practiced today, where you think we have somehow lost sight of the nobility of our profession?
I think money has become the sort of hallmark now of the profession. It's a question of who's going to earn the most money. People are attracted by money. They go along with those who are in power. This is what we have seen over the last 10 years. Most of the professionals align themselves with those who are in power. The minority seems only 1 or 2 lawyers, not more than that. So that the money sort of seems to dictate the agenda. So we have to get out of this, especially the most senior members of the bar, because you have got at least 1,000 juniors out there. But then it's for the senior counsel to take the lead.
To show them the example.
But of course, because they are able to bring the more important cases before the courts, especially when it comes to human rights and so on and so forth. Matters concerning the public interest, the need to do pro bono work, etc. Very few people do pro bono work. At least a busy lawyer should do at least 1/3 of his work should be pro bono. If you're a highly successful lawyer and you're earning a decent living, I think you should sort of give back something which has been given to you. And you have to assume that responsibility. This is how it happens elsewhere, because you have the means to do so. And I don't think that is something which is sort of inordinate to expect someone to do at least 1/3 of pro bono work, whenever it is deserving, of course. Yes. You have to pick and choose, obviously.
Of course. Yeah.
But those who are defenseless, those who don't have the means, should be able to have their voice heard in a court of law. See, for example, from Chagos, the islanders, they have had the benefit of top lawyers who have appeared for them before the British courts. For example, Sir Sidney Kentridge, QC, appeared in a judicial review case. He appeared pro bono for the Chagosians. So we should be doing the same here.
And this is exactly what we also had as a guest on the podcast, the former DPP, and he said pretty much the same thing. He said the law has become a business.
Yes, but of course it's a business. Very much so. It wasn't so in the good old days. Since the last 15 years, it is so.
If I may be devil's advocate, because obviously I'm in a structure that is a law firm, do you think with the advent of law firms that has somehow muddied the water in terms of people have started thinking in terms of, law firms run businesses, you have financial targets, your junior would know about it, he's been in a law firm before. And, it's in a way, what I find quite strange in the way we practice law in Mauritius is that I used to practice as a solicitor in the UK, and law firms would be solicitors. And barristers would be self-employed in chambers, whereas in Mauritius it's almost the other way around.
The other way around, yes.
Yeah. So I don't know whether that has, because you mentioned 15 years.
That has had an impact probably in the mindset. Those who have been earning high income earners in US dollars, now they only look at money. They are not concerned with anything else. Time is money. But I don't think that time is money insofar as a barrister is concerned. He ought also to undertake some work on a pro bono basis, especially if he's a very successful and affluent lawyer. He must give back to the profession something which has been given to him. So I don't see anything wrong with that, even if it is a law firm. So what? You have more means, you are much more organized than someone who is working alone without any backup, anything. If we are able to do 1/3 of our work is pro bono, then
why can't a law firm
a law firm do the same? Well, they don't have to go into 30%. They can do less. They can do 10%, 5%, whatever they feel, But some people now doing, they have got pro bono clinics also now.
Yes.
Yes, but it should come also from those who are la crème de la crème on top also.
And you feel this is
lacking? Yeah. It should be much more generalized, because you are supposed, when you are at the bar, it is an independent body. The bar has got to be independent from the opposition and the government of the day.
Of course.
can't just toe the line of the executive, because that suits your financial interests. This is what we have seen for the last 10 years. This is what I'm against. So you have to preserve the bar as an independent institution within the state. And you must not forget also that the bench is an emanation of the bar.
Yes.
You see?
Yes.
So you have to preserve that independence at all costs.
And have you been, and I asked that the same question to the former DPP as well, because he was in tremendous pressure at various points in time. Do you feel that you have always been able to practice your profession without fear or favour?
Yes. Yes. It depends on the way you organize yourself. You must preserve your independence at all costs. And you have to do it fearlessly. Otherwise, it's difficult for you to represent the interests of other persons. If you are fearful, you have got other vested interests in mind, you can't function properly. There will come a time when your reputation will be in shatters, especially in a small jurisdiction such as Mauritius. Everything is known.
Everything is known.
Yeah.
And we love gossiping.
Not only about gossiping, but people
Yeah.
are aware of
Yeah.
what is going on.
Yeah.
They know for themselves, you know. If you are going to kowtow to the executive, then even the English judges have said so. There was a famous dissenting judgment in the UK where one of the judges said, I tremble to think of those judges who are more executive-minded than the executive.
Wow.
That was during the Second World War. That was during the Second World War. They wanted to deport someone who was supposed to be an enemy alien from the UK. And the judge said in his dissenting judgment, even amidst the clash of arms, the voice of the law is not silent.
Wow. That's deep. Do you remember who it was?
It was a famous speech. It's very easy to find it online.
Yes,
Even
I'd
amidst
love
the
to
clash
read
of
it.
arms, the voice of the law is not silent. And I think he ended by saying, I tremble to think of those judges who are more executive-minded than the executive. So
That's
you have to
very
be
powerful.
independent
Yeah, yeah.
from the executive, and you have to preserve the rights of the citizens also.
And also independent, and I put a post recently on that. It was specifically on the cabinet rule, but it was also about independence. And that also reminds me of, because I often ask that of family lawyers and criminal barristers as well, is that you also have to remain independent from your client's interests as well, in the sense that you have to act in your client's best interest, but you can't be drawn into your
Exactly.
client's cause, into your client's emotions and
Exactly.
drama. That's also independence.
You have to preserve your independence from your own client. Yes, I agree entirely. This is something which is essential. You can't be the mouthpiece of the client. You can't. Very often the client wants to draw you into the emotional aspect of it, etc. They want to sort of, as someone famously said, bouche disait, fais-moi t'identifier.
I love that expression. We'll put that in the teaser, Natasha.
So it says it all.
Yeah. How did you find that easy to do though? Because I suspect it's quite hard though, because we're all human.
No, this is the way I have functioned since the very beginning. This is the way I was taught by my seniors. You need to preserve your independence and objectivity, the way you run your practice, the way you run your own affairs. You have to preserve your independence. And the more varied the practice you have, so you hedge your bets basically. You don't depend on a single client. If you depend on a single client, but that's the end of it. You are no longer independent. You have to preserve your financial independence, and you must also be very objective in whatever you do. If you lose your objectivity, it's gone. Even your reputation towards the court, they will say, this man is, he has no objectivity whatsoever. We can't rely on what he says. He's the mouthpiece of the client. That's the end of it. Your reputation is in tatters insofar as your own colleagues are concerned. No one will respect you. The court will have no respect for you. You have to earn the respect of your peers, and you must earn the respect of the court also. And that's the only way to earn that respect. And the reputation is easily gone. It's very difficult to build a reputation.
But it can just go like that.
It can go like that, huh?
Yeah. Yeah.
Because there was someone who was a former Queen's Counsel when he was appointed in 1982. There was a 60-0. So he was appointed in Delhi because he had married an Indian lady. So he thought he was gone for the next 30 years or so, 60-0. He was back after 1 year because the whole thing 60-0 crashed. So the fellow had to come back, and when he was in Delhi, having observed what was going on there, some of them were selling whiskey bottles, black market and whatnot. So when he arrived there, he said, "Gentlemen, we have got a reputation to lose."
I love that. I love that. Wow.
So that was in 1982.
Got an amazing memory.
When the fellow assumed duty as ambassador there in India. We have got a reputation to lose. So there you are. It's up to you to decide where you want to go.
What advice would you therefore have for, and I often ask that question of seniors as well, because you started practicing at the time where there were a handful of lawyers. Now there's over 1,000 barristers. Not all of them choose litigation, but a good chunk of them do litigation. And they struggle. They struggle because there's not enough work, because they feel like there's a lack of mentoring. Perhaps they don't want to put in the effort because they have other interests in life. So what advice would you have for them?
I think you have to get organized, and you have to know how to manage your practice also. And you must look for your own particular area of expertise and where you're able to earn a living. Otherwise, you go and you can apply to be a state counsel or else. I think it's easier now to earn a living now, today, than it was in the 70s.
Do you think?
Yes. There were very few briefs.
Right.
It was very difficult to earn one living in those days. I think it's easier today. There are many more cases now, and the law has become so evolved that you need to go to a lawyer for almost anything now. And the amount of administrative cases, the amount of tax cases, etc., on the rise.
Yes. Yes.
There were practically none at the time. Even someone would scarcely have a retainer from an insurance company. It was a closed shop. Even civil cases were very few, far apart. You only had the occasional doc brief. Most of the lawyers were sort of earning their livelihood, struggling on the odd doc brief, 50 rupees, 75 sous, whatever it is. And the time in the 1950s, 1958, when you became a barrister, they told you, "Mettez mon mot de fin, elle fait le dentiste."
And you still thought that was the right profession for you, because it must have been hard when you started.
No, I don't think it's hard. We have had a lot of assistance, help from our seniors also. I think it was harder then than it is now.
Right. Is there anyone in particular that stands out as a great mentor to you?
Antoine Domingue, and then there was Mauritius also, who was a Queen's Counsel. He was someone who did his pupillage with Quentin Hogg, the famous Lord Hailsham.
Mm-hmm.
Yeah.
Okay.
The man was Oxford fellow. When Mandan was doing his pupillage there, so he had observed that the man, when he received the papers, very often he would be editing the papers in the margin with 2 O's. So what is this? I am a classical scholar.
Right.
I am a classical scholar, so I have read Latin and Greek.
Okay.
And I have to think about the girl who's going to retype the papers. But at the same time, I can't sort of repress my feelings. So when something is wrong, I put 2 omicrons. Then solicitor knows it means balls.
Oh my goodness! I did not see that one coming.
That was Quentin Hogg.
Wow.
He's the one who delivered the famous speech in the judgment, the case of the fellow who was sentenced to 12 weeks imprisonment because of contempt of court against the Commissioner of Inquiry. He delivered that particular judgment at the time. Lord Hailsham. The famous Hailsham edition. He's the one. Quentin Hogg. His father was an Attorney General at the time.
Right.
And Denning writes about the father of Quentin Hogg, says he looked like Mr. Pickwick, but he spoke like Demosthenes.
Oh. Do you feel nostalgic of that time?
Yes, I think so. You don't have these towering figures now who would be able to command, the whole audience. The fellow, at one point, he was the deputy chairman of the party, of his own party. He wrote an autobiography, Sparrow's Flight.
Okay.
Yeah,
Okay.
worth reading.
Yeah, I'll look it up.
Old Hailsham. The Sparrow's Flight.
I mean, even if we go outside Mauritius, I remember when I was studying, one of the first judges you heard about was Lord Denning. I don't know whether there are such.
He was brought up before Denning, Court of Appeal,
Okay.
because he had written an article, because he was a politician, this fellow. He was the
Right.
Lord Chancellor at one point.
Okay.
He had written an article in Punch saying that that judges should remember the golden rule. This is Hailsham writing in
Okay.
Punch. Judges should remember the golden rule, silence is always an option. So there was someone, an MP, who brought contempt proceedings against him before Denning Court of Appeal. And Denning, having heard the case together with two other judges, dismissed the application for contempt, saying,
Freedom of speech.
when things are ill done, silence is not an option.
Oh.
That was the concluding part.
Right. Oh, I'm going to look up all these cases
But it
now.
was
Fascinating.
dismissed because of freedom of speech.
Yes.
Obviously.
Yes. It's an opinion. Yeah.
Yeah. That was Quentin Hogg, at his level best.
Last question for you, Antoine. Maybe that should have been, first question. I don't know. In your professional career, out of all the cases that you've done, has there been any regrets? Any case that you wished you'd done differently, or you wish the outcome was different, or where you felt you could have done more?
No, I don't think so. No, because, the advantage I had read French law. There is a lot of French law in Mauritius. It's difficult to find your way as a general practitioner if you are not very familiar with the French law.
Correct.
So I had the opportunity, because I earned a scholarship, and then I read a lot of English law and Mauritian law in Mauritius also. And I had two tremendous mentors, Juval on the one hand, criminal law, and Manan Ganjador, administrative civil law. Was very good at civil law. I learned a lot from both of them. So I don't have any particular regrets. You make the most of what you have, because you can't go and dig and find out, take from one brief, bring it to another brief, as you well know.
Yeah.
So you make the best of what you have, then there is the outcome. I don't think there are any regrets. If you go by the rules, you play by the rules, I think you can't go wrong. Yeah. You need to have your bearings right in your mind when whatever you do in life.
Yeah.
You know where you're going.
I always say that so long as you're first, I call that first principles. So as long as you're clear in your mind what your values are, and I don't think you can ever go wrong. Maybe.
Yes. What are the basics, first of all?
Exactly. The
and
foundation.
then you need to know where you're going, in which direction you're going. So this is the most important part.
Thank you.
You have to be true to yourself, first and foremost.
Yes. Sorry, I've got one last question. I just thought of it now. Do you feel, because I asked that to, I think, Patrice de Spéfil, if I'm not mistaken as well, whether is the law something that you feel you will always have time to keep on doing, or will there be a time where you felt, okay, I've done everything that I wanted in my career, now I'm just going to go gardening or traveling?
No, I don't think so.
Really?
No, I'm so passionate about it that I feel that I should continue, if I am able to continue.
Of course.
Intellectually and physically. If you can't, intellectually you can't do it, then you can't, obviously, because there is no point. Then it will be at the expense of your client.
Of course.
And it will defeat the ends of justice. But so long as you can and you enjoy it, the problem if you no longer enjoy it, this is when it becomes rather difficult.
Yes, but you still enjoy it now.
I still enjoy it, so I carry on.
Thank you so much.
Thank you.